area to guide us through this. Mark Mangan, who I'm sure all of you know, has practiced in arbitration for over 25 years. He was the initial chair of the ICC Australia Arbitration Steering Committee, which is hosting this, and he's also a member of the ICC Court. Nivvy Venkatraman is a senior associate at HFW at Australia in its Sydney construction team.
Just a meeting. I thought this was another call. I have to call that tomorrow. Thanks, sir.
Somebody needs to turn their sort of speaker off. And she focuses on domestic and international commercial dispute resolution through litigation and international and domestic arbitrations, and has a broad experience including building and construction, renewables, property shareholding, insolvency, and general commercial disputes. Prior to joining HFW Australia, Nivvy was a senior international case counsel at a regional arbitral institution in the Asia Pacific region, and is currently an ICC YAAF regional representative for Southeast Asia for the 2024-26 mandate, as well as the Australian representative for the Asia Pacific Forum for International Arbitration. What I thought I might do is just ask Mark to start off with how the court developed these new 2026 rules.
Thank you, Stephen, and hello everyone. It's good to see familiar faces on this call. Thank you for taking the time to be with us this afternoon in the midst of your busy schedules, and we very much hope that you'll find it worthwhile and provide some insights perhaps that you may not otherwise have had. As for the development of the ICC rules, it could be said that they've been developed over 103 years since the ICC was established in 1923, during which time the institution has managed some 30,000 cases, which has led to multiple iterations of the ICC rules through lessons learnt. The penultimate set of rules were, of course, from 2021, not 1921, 2021. And the review process for those rules began in March 2024. And the ICC undertook a multi-year process where they sought views on those rules over an 18-month period from some 1,400 delegates involved in the ICC Commission on Arbitration, and received input from 57 national committees. Hopefully the Australian National Committee was among them, although I'm not entirely sure. Someone on this call may know whether we actually made a submission. I know here in Singapore, and I was involved in a process that led to the Singapore National Committee making proposals to ICC in Paris, but I'm not sure if Australia did. And ultimately, it was considered by the ICC court in various sessions, some of which I participated in. And then I don't know if everyone on this call knows, but the ultimate body that determines whether or not rule changes are made is the ICC Executive Board. And I might even during this call put a link in the chat on providing details on the ICC Executive Board, because it comprises people that you may not be familiar with, yet they are all powerful ultimately within the ICC. They determine whether changes are made to the rules, and they also determine the selection of the Secretary General and the President of the ICC, for instance, and they'll be engaged in a process that in relation to the renewal of the ICC presidency next year. So that's the ICC Executive Board. They ultimately signed off on the rules, and they came into effect on the 1st of June this year.
Thanks, Mark. Well, first of all, can I ask Nivvy, the new rules have done away with mandatory terms of reference and have made some new provisions about case management conferences. Perhaps you could elaborate on how that's going to work.
Sure. So firstly, thank you to ICC Australia for having me as part of this session. It's truly a privilege to be here. As mentioned, one of the key changes in the 2026 ICC rules is the removal of the mandatory terms of reference. Now, historically, the terms of reference have been considered a hallmark of the ICC rules, and the underlying purpose of the terms of reference has been threefold. The first purpose historically has been that it's confirmed the parties' consent to arbitrate, particularly in circumstances where they've had to enter into a submission agreement to refer the dispute to arbitration after the dispute has arisen. The second main purpose of the terms of reference was that it recorded the key procedural arrangements at an early stage during the proceedings. And the third purpose was that it also defined the scope of the dispute, typically through a summary of the parties' respective claims, the reliefs they sought, and the amounts of any quantifiable claims that they may have. Now, the substantive sections of the terms of reference are normally prepared by the parties and circulated to the tribunal for consideration ahead of the first case management conference. And obviously, this requires a decent amount of both time and effort from the parties to prepare a concise summary of their respective claims, the relief sought, and if the tribunal requests them to do so, to also prepare a list of the issues to be determined. However, in practice, the terms of reference have often been considered to have minimal utility, particularly when it comes to materially narrowing the dispute at an early stage of the proceedings. So in practice, what tends to happen is that the parties in the tribunal tend to place greater reliance on the matters that are actually contained in Procedural Order Number 1, as well as the procedural timetable to manage the conduct of the proceedings. So this reality was acknowledged by the ICC when they considered revising the arbitration rules. And what they specifically observed was that under the expedited procedure provisions, which were introduced as part of the 2017 ICC arbitration rules, there was no mandatory requirement under those provisions to have a terms of reference. And notably, out of the 1,000 or so cases that have been administered under the EPP, there have been fewer than 25 tribunals have actually decided to draw up a terms of reference. So what that's indicated is that it is possible to have a successful arbitration without the need for any terms of reference. And that's the history behind why the mandatory terms of reference have now been removed from the ICC rules. Having said that, it's still open to the parties if they consider it necessary to do so in their particular case to agree on the inclusion of the terms of reference. So from a practical perspective, what does all this mean? So under the 2026 ICC arbitration rules, there's now a greater emphasis on the initial case management conference, which effectively makes the initial CMC a key procedural milestone around which the proceedings are structured. So under the 2021 arbitration rules, there was no real timing requirement around when the initial CMC was meant to be convened, aside from it needing to be held either while the terms of reference were being drawn up or as soon as possible thereafter. However, under Article 24.1, of the 2026 rules, the arbitral tribunal is required to hold the initial CMC within 30 days of receiving the case file from the Secretariat. Now, either during this initial CMC or soon thereafter, the tribunal's then required to establish the procedural timetable, which needs to be communicated to both the Secretariat and the parties. Similar to the 2021 rules, Article 25 of the 2026 rules also contains the provision around the time bar for making new claims. And under the new Article 25, it says that after the initial CMC, a party cannot make new claims unless authorised by the arbitral tribunal. And in determining whether or not to authorise the new claims, a new consideration for the tribunal is to consider any cost implications that might arise from a party's request to make new claims. That wasn't part of the previous iteration of the rules. So holistically, what this means is that in the absence of a terms of reference, the parties need to pay more attention to how their claims are articulated in the request for arbitration and in the answer and the counterclaim stages to ensure that all the relevant claims are captured and are fully and comprehensively described as possible. This is because you can't rely on the terms of reference anymore to be used as a fallback to further particularize or articulate the claim after you've submitted your initial request or answer in the arbitration. Now, in terms of the ICC's guidance notes, the ICC has indicated that they will be, they're working on a model procedural order 1 that's going to include some key elements or key items for considerations for the parties and arbitrators to consider, which will include provisions around the identification of the parties, the scope of the tribunal's jurisdiction, and the applicable law, which used to be found in the terms of reference but can now be moved over to be included as part of procedural order 1. Although, having said that, many of the procedural orders that I've seen have already included those key elements. So that won't be too much of a drastic change.
Thanks, Nivvy. The new rules, Mark, contain provisions for early determinations and ex-parte interim relief from emergency arbitrators. You want to quickly outline those?
Yes, thank you, Stephen. Before I do, I might just take a quick straw poll. Could anyone could anyone who's going to miss doing the terms of reference in an ICC arbitration, could you raise your hand if you're going to miss doing it? Or maybe raise your hand now if you're happy that you won't have to do it. But you can. But there were benefits to it in terms of crystallizing the thought processes of the tribunal members, getting them engaged, making them look at early pleadings and the positions of the parties. But it's probably going to save time and cost dispensing with it. Stephen, as for the early determination,
I suppose, Mark, just to say, I think it was painful, but I guess the problem is you never knew when you might need it, right? You look at this, a number of cases where people have relied on those terms of reference, particularly where the seat hasn't been specified, and then the ICC court has designated a seat, and then people have relied on the terms of reference as showing the consent of both parties to the seat. So, yes. You know, I think you don't know when it is it's something that you might actually have wanted to rely on until the situation arises. So that's where I think it's perhaps a bit of a shame. It's no longer mandatory, right? Anyway, that's...
Yep. And Lucy has pointed out that the list of issues was helpful, but often that led to disputes in itself at an early stage where one or more parties are not willing to try to narrow the issues to be determined and wish to delay that until later in the proceedings, and you can have debates about whether or not you should be doing it at all at that point in time, or let alone what the list of issues should be. But as for early determination, the ICC here, I think, is following the lead of some other institutions, including SEAC, in having a provision that allows for the early determination of claims or defences on the basis that they are manifestly without merit or manifestly outside the tribunal's jurisdiction. I think in many ways that's simply a codification of what tribunals could already do. Tribunals have always been empowered to take an early view of things if they felt they had sufficient information, or if it was so obvious, in this case, using the words of the ICC rules, manifestly without merit or outside their jurisdiction, they could rule upon a claim, defence, or on the tribunal's jurisdiction at an early juncture. Stephen, in relation to your second question in relation to ex parte interim relief, what the SEAC refers to as a preliminary protection order, PPO, and which the ICC refers to as simply as a preliminary order. What's interesting there is now under the ICC rules, which could not be done previously, so this is not a codification of prior practice, this is a new innovation, which is it allows parties to seek ex parte interim relief. And I think SEAC introduced that with its rules in 2025, and I think the ICC is to be applauded for doing likewise. I think one of the themes that we can talk about for the next 14 minutes is the impact of some of these innovations on arbitrators, because then I know Erica and Lucy and Amanda and Caroline and others on this call, and of course Stephen, sit as arbitrators. I said something similar to what I'm about to tell you now in relation to the SEAC rules a year or so ago when they first came out, which is this is great that a preliminary order can be obtained from an emergency arbitrator, but of course it increases the burden on the emergency arbitrator, who now may have to make 3 decisions within 14 days. So you need to make a decision initially on the ex parte interim relief. Then the party that did not have notice of that application then needs to be given notice and can make submissions. You then have to rule promptly on those submissions. And then thirdly, you have to actually discharge your ultimate function, which is to rule upon the request for interim relief. And maybe within the four walls of this discussion, not to be published, Emily, on the website, that's without any additional fee for the arbitrator. And I think many, and there's nodding of heads, I think many of us would still want to do this because it's interesting and innovative and it's supportive of the process. But over time, just query, whether the arbitrator should in fact be being paid more. And I've noticed that the ICC has increased the application fee for emergency relief from $40,000 to $50,000. What's not clear to me is whether that additional $10,000 will be going to the arbitrator or the institution, or to what extent additional payments will be paid to the arbitrator if they are in fact having to rule upon a request for preliminary relief within 24 hours. I invite any comments or questions on that.
Well, I guess, Mark, just to play devil's advocate, I mean, it's not dissimilar to the fact that you can have to rule on a whole lot of interlocutory applications as an arbitrator in one arbitration. I've got one at the moment, which is a expedited arbitration where there has been multiple interlocutory applications. I don't get any more fees for doing that versus a standard expedited arbitration where all you're dealing with is if it's on the documents, right? So I guess they're sort of thinking of it in the same way. But I agree with you, that certainly will increase the burden on arbitrators.
Well, now maybe we can move to the next topics for Nivvy, which are the expedited procedure, monetary threshold that's changed, and the highly expedited procedure.
Sure. So under the expedited procedure, the main revision there is that the threshold amount for arbitration agreements that were concluded after the 1st of June has increased to 4 million. The previous threshold amounts of 2 and 3 million for arbitration agreements concluded prior to that date remain as they were. And the ICC's rationale for the price increase was that over 40% of the ICC's cases didn't exceed US $4 million in 2025, and that was considered sufficient for broadening the range of disputes that could be eligible for expedited arbitration. Other than that, under the expedited procedure provisions, the only other key point to note is that the timeline for rendering the final reward is now within 6 months of the date of the initial CMC, and it can be extended by the President of the ICC Court pursuant to a reasoned request from the tribunal or on the President's own initiative. But I think what's more important to focus on is the new innovative introduction of the highly expedited arbitration procedure, which the ICC refers to as HEAP, which is set out in Appendix VI of the 2026 rules. Now, my reading of this new mechanism is that it's aimed at lower level, lower complexity disputes. There's no monetary threshold for or limit on the quantum of any disputes that can be referred to the HEAP mechanism, provided that there's a low level of complexity overall in the dispute. Now, in terms of the unique features of the HEAP mechanism, its most notable feature is that the arbitral award needs to be rendered within 3 months of the date of the initial CMC. Obviously, that's incredibly ambitious. And to achieve this, the ICC rules have essentially front-loaded the proceedings And what I mean by front-loaded is that if a party wants to enliven the heap mechanism, then as part of the claimant's request for arbitration, the claimant needs to simultaneously file both the request as well as the statement of claim, including any evidence to the extent that's possible at the outset of the proceedings. Then the respondent has 20 days from when it receives the request and statement of claim to submit its answer and its statement of defence, as well as any statement of counterclaim, following which, if there is a statement of counterclaim, then the claimant has a further 20 days to submit any reply to the counterclaim. All of this has to be done with the relevant evidence. So it's effectively like preparing a memorial, just in a very expedited fashion. So in practice, I don't know how this is going to pan out, but as long as it's restricted to very low complexity disputes, like very straightforward payment disputes, then maybe it's something that will be achievable in practice. To help expedite the process, under the heap mechanism, you can only have a sole arbitrator who's to either be jointly nominated by the parties within 20 days, failing which the sole arbitrator will be directly appointed by the court. And once the sole arbitrator is appointed, they need to hold an initial CMC within 7 days of receiving the file from the Secretariat. Now, similar to the expedited procedure, under this mechanism, the sole arbitrator, again, has very broad discretion in terms of the procedural measures that they can adopt to ensure that the arbitral award's rendered within the time limit. So these powers include the arbitrator deciding not to allow requests for document production, limiting the number or the length or the scope of any written submissions or written evidence, as well as dispensing with the need for any hearing or any cross-examination, and essentially conducting a documents-only arbitration. One of the more novel features of the heap mechanism is that, unlike other ICC arbitration proceedings, it is possible for the sole arbitrator to render an award without reasons, provided that the parties agree to the arbitrator dispensing with reasons. Now, I looked into the ICC's rationale for this, and it appears that there was a report published back in 2024 that was focused on cost efficiencies for small to medium businesses, where it was found that an award without reasons may be appealing to small and medium enterprises for its time and cost efficiencies, particularly in expedited proceedings, low-value disputes, or where the issues in disputes are technical in nature. Now, obviously, if the parties do decide to dispense with having a reasoned award, one of the main things that they need to consider are any enforcement issues that might arise from that. And to factor this in, the latest ICC note to the parties and arbitral tribunals on the conduct of ICC arbitrations contains a provision which states that the court and the sole arbitrator shall make every effort to ensure that an award under the heap mechanism is enforceable at law. Having said that, though, the onus is still on the parties to make sure that they've adopted the right course of action in deciding to dispense with the need for reasons.
Thanks, Nivvy. Mark, the vexed question of arbitrator disclosures, at least for people who are like me, is taking sort of a new step further in the new rules, and there's also something in there removing time limits. You want to talk about that?
Yes, briefly, the ICC rules has shifted some elements that were previously in the practice note issued to parties and arbitrators in relation to arbitrator disclosures, and what was previously essentially still required through that practice note is now embodied within the rules themselves. But going beyond that, the new rules in Article 12.5 require disclosure by the parties of persons that they believe are essentially connected to the arbitration that should be the subject of a conflicts check by the arbitrators. Essentially, I think what's happening there is the ICC is seeking to shift some of the work that it currently carries out when it analyzes the file to work out who is potentially affected by the case. And those on this call that have sat as arbitrators in ICC cases, you would have received a list of persons' names and entities that are potentially related to the case beyond those of the parties. And essentially, I think the ICC is seeking to shift the responsibility for that analysis to the parties themselves, which is understandable. As for time limits for awards, as Nivvy said, there's now no terms of reference, so there's no point linking and the time within which the award has to be rendered with regards to the terms of reference. So I might just ask for a show of hands again for those that have sat as an arbitrator in ICC cases, or indeed appeared as counsel, where you've received more than one letter extending the time limit for the rendering of an award. I'm sure you have, Lucy, because they will send it regularly under the 2021 rules, because they have to, because under the previous rules, the award had to be rendered within 6 months of the terms of reference. So what the ICC Secretariat would do is automatically generate new extensions of time that would be sent out. And I think there's also a case of false expectations being created in parties expecting that awards would be rendered within 6 months of a terms of reference, which in practice almost never happened. So I think the ICC is to be applauded for dispensing with that, and instead providing for the ICC president to set a time limit with regards to the specifics of the case, in particular the procedural timetable that the tribunal has set in consultation with the parties, and setting the date for the award to come sometime after the final hearing and after the final submission. Presumably it will be within, for a 3-person tribunal, it will be within 3 months of the final submission that's expected, and for a sole arbitrator within 1 month of that, consistent with the ICC's practice with regards to the payment of arbitrators, expecting awards to be rendered within that time frame. So I can perhaps stop there, Steve, in the interest of time.
Thanks, Mark. Nivvy, the rules have dealt with electronic communications. Is there anything exciting about that, or should we move on?
Well, I think we can probably move on. I mean, it's pretty straightforward. It's now expressly stated in the rules that the default position is that you can communicate by email to the Secretariat. And I think part of that is also the ICC is trying to use it as a soft way to kind of promote the use of the ICC digital case management platform, ICC Case Connect. So there's nothing novel about that.
Welcome to the 21st century. Mark, fee adjustments, as the new rules deal with this.
Yes, thank you, Stephen. So the ICC continues to charge fees on an ad valorem basis, consistent with SEAC and AKICA. But I think unlike those institutions, you cannot develop your own bespoke method of remuneration. Certainly, SEAC allows parties to reach an agreement, including potentially paying arbitrators on an hourly basis, but I don't think AKICA does. I think AKICA allows that as well. I think that allows bespoke arrangements. Is that right, Erica?
AKICA's only hourly rate. They don't do ad valorem.
Is that right?
Yes.
Okay. Well, my mistake. So sorry. Well, ICC only does ad valorem. And there are pros and cons to that, but it's consistent with its long-standing practice, and I think parties have gotten used to it and still support ICC arbitration, and no doubt appreciate the certainty that it provides with regards to the expected costs. But unlike some other institutions, there is no cap in the fees that are payable to arbitrators under the ICC rules. Which is interesting. If you have a multi-billion-dollar ICC arbitration, in theory, the arbitrator fees could be multi-millions of dollars. In practice, that doesn't happen, and it's important to let your clients know that. The ICC almost always only awards so-called average fees, and the ICC cost calculator tells you what those average costs are likely to be. For a multi-billion-dollar case, it will not be the maximum amount that potentially is infinite, depending on how much is in dispute. sadly, for those that want to do multi-billion-dollar ICC arbitrations as arbitrator. But the ICC has reduced its fees for low-value disputes, I think, which is to be applauded. So for disputes that are valued under $10 million, the arbitrator fees and institutional fees, so the institutional fees have been reduced while the arbitrator fees have stayed constant as a function of the amount in dispute. The filing fee has also kept steady at $5,000, but new filing fees have been introduced, which some of your clients may not appreciate. A filing fee of $5,000 for a joinder application, which SEAC introduced in 2025. I already mentioned on this call that the EA application fee has been increased by $10,000 to $50,000. But there's no fee for arbitrator challenges, which SEAC has introduced, interestingly, perhaps as a way to discourage arbitrator challenges. And the maximum ICC fee, while there's no cap to arbitrator fees, the ICC administration fee is capped. Previously, as is the SEAC institutional fee, previously it was capped at $150,000 US for the ICC institutional fee. It's now increased to $180,000. But that's the first increase in that amount for some 10 years. So I think that's perhaps reasonable. Perhaps I'll just leave it there, Stephen.
Thanks, Mark. Nivvy, the administrative tasks for the ICC court are now a bit different under the new rules. Do you want to just outline briefly that?
Sure. So there are some of the administrative functions that were previously performed by the ICC court have now been transferred to the ICC president. For example, fixing the time limit for the rendering of the final award. Some of the powers have also been transferred to the Secretary General, such as fixing the advance on costs under Article 40. The purpose of these changes is essentially just to increase efficiency. Otherwise, it appears that most of the other functions have been retained by the ICC court, and this includes deciding challenges to arbitrators, scrutinising final awards, and fixing the costs of the arbitration.
Thanks. And Mark, are there, despite all these changes, is there something in the future that might be dealt with, like you're dealing with the rules don't deal with artificial intelligence, or requiring anybody to say was artificial intelligence used to prepare a submission or evidence or the like, or arbitration awards? What future hold here?
A lot. I think there are many task forces that are currently underway looking at some of those issues, including the application of artificial intelligence in international arbitrations, both by the parties and arbitrators. And some arbitrators are already incorporating within their procedural order number 1 reference to the use of artificial intelligence. And for those that want a precedent on that, I'll be happy to provide one. Not one that I drafted, but one that a tribunal circulated in recent times that I thought was very good in acknowledging the use of artificial intelligence. And we, as counsel, fine-tuned it somewhat to provide some protections against the misuse of artificial intelligence. But I think that's going to be unavoidable as we go forward, and progressive arbitral institutions will start to incorporate some reference to artificial intelligence, I think, within their rules and or at least their practice notes as to how it's to be dealt with. Similarly, the recovery of third-party costs, which the ICC has steered clear of, and perhaps that's wise, because as I mentioned to an audience in which Amanda was, I think, part of that audience on last Friday, as a matter of Singapore law, in recent times, there's been some doubt cast on whether, as a matter of Singapore law, you can recover third-party funded costs. I think you can, but there's an arbitral tribunal that has ruled that you cannot. And the Singapore International Commercial Court, in a judgment rendered by Roger Giles, formerly of the jurisdiction in which many of you currently sit, has rendered a decision which somewhat ambiguously traverses this subject, and on one interpretation suggests that as a matter of public policy, you cannot obtain third-party funded costs. Again, which I think is wrong and in need of clarification, but perhaps the ICC was wise not to go near that issue expressly. I think SEAC has gone closer than the ICC. Again, not expressly saying you can recover third-party funded costs, but using the expression legal or other costs within the rules, which has been interpreted by the English courts, for instance, and others as extending to third-party funded costs. But I think that's a topic to be addressed in the future by task forces, in practice notes, and possibly within institutional rules. And then thirdly, I just might mention the environment, because I know there are people on this call that think very strongly about the impact of arbitration and arbitration-related services on the environment. And AKICA, for instance, through its sustainability task force, has adopted a protocol in that regard, which was recognised in the GAR Awards last year. SEAC in its rules last year, the 1st of January 2025, made express reference to tribunals being able to take the environmental impact of procedural decisions in their decision-making process. So they can have regard to the monetary cost as well as the environmental cost when making determinations as to the appropriate procedures. The HKIAC has gone further and has said, consistent with an article I wrote, if I may say, in 2022, that a tribunal can actually take into account the environmental effects of a party's conduct when allocating costs, which I think is progressive. Interestingly, the ICC is silent on the environment in its new rules, and I think that's an area going forward through practice notes and/or in future iterations of the rules where perhaps there can be express reference to the environment. Not that it's going to change much, but it can simply just encourage a discussion, a conversation with the parties about choices of hearing location, whether it should be done virtually or in person, or hybrid forms, and other decisions. Having it within the rules can help inspire those discussions and hopefully lead to better decisions.
Thanks, Mark. Are there any questions anyone wants to ask? Kate, have you got a thing on, Kate? Do you want to ask something? Or am I looking at something that looks like a yellow hand and it's not at the bottom of your screen? Anyone else wanting to ask a question? Put up a hand now or forever hold your peace. Well, I certainly found the talk from both Mark and Nivvy to be very informative and helpful, and I think we're all grateful to both of you for the preparation you put into this and for what you've been able to explain as to the new rules and how they work. So thank you both very much for what you've done, and I'll let, if Emily wants to close or have anything to say, otherwise we will close the meeting.
Thank you very much. I leave it in your safe hands, and thank you very much to Mark and to Nivvy for the excellent session, and to Judge Reyes for moderating. It was really informative and excellent. Thank you.
Thanks, everyone. Have a good
Thanks,
night.
guys.
Day.
Good to see everyone.
I've put a link in the chat for those that want to read about our insight on what we discussed today.
Thank you.
Thank you.
Thank you very much.
Thanks. Bye.
Thank you.
Thank you.